Hello, good morning, everybody. It is early, very early. As a matter of fact, it's 8 a.m. Um, here in Pennsylvania, Eastern Standard Time. Um, I believe some of you are on your way getting ready for work. Others of you have probably taken the day off to kind of travel and go visit family. And some may just been given the day off because of the holiday on tomorrow. So I just want to say happy holidays and happy Thanksgiving. I wanted to come out early because I have a full day and I wanted to discuss this question quickly. I was asked by several different people if I could do a question on subpoenas and court orders. And so I thought I'd just start very simple and give a question that's focusing on using the word subpoena and understanding a court order. So I'm going to go ahead and get started because I do have to go to work as well. But I just kind of wanted to talk about this quickly and pretty much give you some ideas in reference to how you need to think about this and how you need to think through this and understanding the difference between a subpoena and a court order. Okay, for those of you who don't know me, my name is Bridget Montgomery, and I'm a master's social worker. I'm a licensed clinical social worker. I also hold a master's of science in nonprofit management, and I am a certified sex offender treatment specialist. This is what I do. This is what I love. I love teaching, I love supporting, and I love helping. So let's go ahead with the question quick. All right. So most of you already probably read the question and answered it. I did put the correct answer and the rationale in the comment section for those of you who already read this question and answered it. But for those of you who's just catching it for the first time, we'll read it together and we'll go over it. Okay, so the question reads as such. You were subpoenaed by the court of law to turn over all your clients' evaluative reports. What is your primary responsibility? A, follow up with your state law and NASW on how to proceed, then respond to the court order and do as instructed, and then notify the client. B, get release from client first pertaining to what they want sent to the courts. C, assert privilege on behalf of client, understanding therapist-client confidentiality. Or D, ignore the court order altogether. Okay, so this, as we know, is not an analytical kind of question. And so we understand this to be a recall type question. This is one of those types of questions that you'll see on the exam, not quite written in this fashion, but sort of similar, that will be recalling or assessing your knowledge and understanding of a particular content area. Now, what I want to say to you is that this is very important. You need to know this. At some point in your career, there's a strong possibility that you may run across a situation where you may be subpoenaed or receive a court order, especially if you're working with children in foster care, adoptions in hospitals, if you're in private practice or counseling and you see couples, you're doing divorce cases or anything like that, there's a strong possibility that you will at some point come across receiving a subpoena or a court order. I've received many subpoenas in my day, and when I was doing forensic, I also received court orders. So there is a slight difference in terms of what they are and how do you know the difference. Okay, so here, let's take a look at the question. What I need to really point out is the fact that, notice I highlighted the word court of law. So if you see a question, and this is just for the purpose of taking the exam, if you see a question that's referencing court of law, you want to pay attention to that, because what that is suggesting is that it's coming from a judge. All right. And if you get a subpoena from the court of law, what you're essentially getting is a court order. So a subpoena from the court of law translates into a court order. So you may not see the word a court order in any of the test questions, and you might. So it could go either way. They could be used interchangeably. So if you receive a subpoena from the court of law, that's suggesting that you've received a court order from a judge. All right. And getting a court order from the judge, you have a responsibility to respond. All right. So knowing that court of law is suggesting that that's a court order coming from a judge, then what's your responsibility? What must you do? A, follow up with your state law and then ASW on how to proceed, then respond to the court order and do as instructed. B, get a release from the client first pertaining to what they want sent to the courts. C, assert privilege on behalf of the client. Or D, ignore the court order altogether. Well, we can easily say that this is a no-go, right? So we're not going to just ignore the court order altogether because we have a responsibility. And if you ignore a court order, there is some ramifications for that, okay? Do not ignore a court order, all right? You will be held in contempt. You will be held responsible for that if you ignore a court order. Then we have C, assert privilege on behalf of the client. Well, you're receiving a court order from a judge, from the court of law, from the law, stating that this is what they need and this is what they're requesting for you. So at this particular point, unless your client has not necessarily said to you, no, I don't want you to send this court order, to respond to this court order, unless the client has responded to the judge after noting that or learning that a subpoena has been sent to you, a court order has been sent to you about turning over their case law, unless they have themselves followed up with the court and wrote an amendment to it or contested it, you still have to follow through. So I kept stuttering over my words. I'm sorry. Someone was texting me through and I was trying to do two things at one time. But unless they kind of contested it, you still have to follow up. Now, if after you find out that they contested it, then you don't submit that information until all is said and done. But in light of you receiving that court order and knowing that the judge has recommended that you or has ordered you to turn over that information, it's your responsibility to do just that. You have to turn over that information. So for now, because we don't see that the client is fighting that or contesting that, or it doesn't say any of that in this particular question, then we want to rule that out. And remember, what's most important is that we always stick to the information that's in front of us. Don't add anything or take anything extra. So it could be a lot of different ways that we can follow up with this or follow through with it. But being that this is only a one level or a one tiered question, and it's only focusing on you receiving that court order, then you have to follow through what's being stated here. Then there's B, get a release from client first pertaining to what they want sent to the courts. Well, at this particular point, it's kind of irrelevant simply because the court ordered you to send the information. Now, I'm highlighting that the court ordered it and not an attorney or not a master's or not someone that's a paralegal or somebody that's representing the client, but the court of law. And the court of law suggests that that comes from a judge. So here the correct answer is going to be A, and it's important that you follow through with that so that you will not be in contempt. And here's the rationale. So if a subpoena is issued by a court of law, it is otherwise known as a court order. So you want to keep that in mind. A covered healthcare professional under HIPAA may disclose protected health information. However, the provider may only disclose the information specifically described in the court order. Now, if you look here, the question says you were subpoenaed by the court of law to turn over all your clients' evaluative reports. So the only thing you're expected to turn over at this particular point is the evaluations that you've written up or the evaluations that you've done on the client. Nothing more, nothing less. That's what's being subpoenaed. that's what you're being ordered to turn over, and that's what you need to turn over. A release of information is not required if the subpoena is legal and if it is properly issued. So it's coming from the court, you're being served that, you need to follow through with that. The subpoena must be issued by the court, state, or federal agency, and it must be specific as to what you need to produce. And as you see in this particular question, the way it was written up, the way I wrote it up, is asking for something specific, and it's coming directly from the court. And then before disclosing protected health information, always consult with your state law and the NASW Code of Ethics as to how to proceed if you believe disclosure would harm your client or patient. To me, I think it's just best practice just to follow up and make sure that you're following through properly, and that you have the backing and the support of the law of your jurisdiction, and that the NAS Code of Ethics, is in alliance with what it is that you're doing as well. And if the court orders that the information is to be disclosed, comply with the court order unless the client appeals the court ruling. At this particular point, the client has to appeal it, but you've probably already submitted that information if they, or if they got to you first because they also received that court order and told you that they have sent an appeal. Then and only then do you hold off on submitting that information that you were ordered to submit. But this is all I have. This is what I wanted to share with you. So I wanted to make the distinction. And if you take away nothing else from here, take away the fact that if you receive a subpoena from the court of law, then that suggests that it is a court order. Okay? So again, a subpoena from the court of law is also known as a court order. Now, you can get a subpoena from an attorney. If you do not have to turn over any records. You can assert privilege. You should notify your client. You should make sure you first have an authorization from your client before releasing any information. You can check with your client about what information is it is that they want to have submitted. Outside of that, you don't have to turn over that information. However, if it's coming from a judge, which is the court of law, which is legal, you must turn over those documents, and there are some consequences if you fail to do that. I did include a link in the question as well as in this video. I included the link because I think it's important for you to also follow up with that information. So I'm going to highlight this link for you. Okay, I'm going to bold it, highlight it for you, and you can take down this link, copy paste it, and then follow up and do some more research for yourself. It's so important that you follow up and do the research on your own so that you could gain a deeper understanding of what's going on. Okay, I hope this information was helpful. I am out of time. If you all have any other questions, you can submit them here in the comments section, and I'll do my best with trying to answer. I probably can't answer everyone or everything, but I will do my best with trying to research the information for you and try to help you or point you in the direction of which you can go for yourself and do that research for yourself. If you need to dialogue about it a little bit more in detail, one-to-one, which I do so much better one-to-one, you can always inbox me for information on how to get one-to-one tutoring. Have a blessed day. Enjoy your Thanksgiving. Enjoy your family and be safe.